For a start, PW1 was not the Auditor General during the execution of the SCA. PW2 testified that he was the Auditor General from 04 to 06. It emerged that one, Mr. Mule, was the Auditor General during the relevant period, and therefore a more appropriate witness to have been called. PW3 also told court that he was not in office at Treasury as Director of Budget. He was there only from July 04. His predecessor in office until December 03 was one Gerard Bisheru, who he testified was still up and about at the time he testified. Edwin Nyaseda, who was Commissioner of Police and Material Time, as already seen, was not called. Instead, Major General Ali, PW16, who confessed in his testimony to not knowing a lot of the matters in issue, was called. This ignorance was not surprising to the court because it is a matter of public notoriety that Major General Ali became Police Commissioner from outside the police service. His predecessor was therefore a more suited witness to testify on the modernization project. Another important witness who was not called is Mr. B. Musioka, Chief Force Amra, at the time the modernization project was mooted and before. His importance to the trial is already addressed. Honorable Chris Murungaru, who was the minister in the contracting ministry at the time where the second accused was PS, was not called, despite signing one of the necessary authorizations for alleged single sourcing that went to Treasury. There are numerous cabinet ministers and PSs in the Treasury and in the contracting ministry during the 10 years that Saudi was sole supplier of security equipment to the police department, who are available and who are not called, to answer some of the difficult questions relating to the company as you heard, especially those relating to the identity of one B. From available documents, these include Mr. Chris Okemo, Mr. Julius Mkulu, Mr. Martin Ogoro Chen, Mr. William K. Kimala, Mr. B.K. Kipule, Mr. Simeon S. Mesirma, Mr. Z.K. Cheruiyot, among others. There is a submission on behalf of the second accused that the court should make an adverse inference that these witnesses, if called, would have given evidence that is adverse to the case by the state. And there's a case cited in that regard, which is Kenya and others versus Uganda of 1972. Finally, I agree with the same submission that none of the witnesses except the investigator directly implicated any of them. Even PW25, that is PS Joseph King, who was categorical that a fraud was committed in the modernization project, did not point it out on any. I now address the individual charges. Count one, to prove that the various accused persons in the charge in count one ever conspired, as alleged, with the intent to defraud the Kenyan public of 40 million euros, which was the contract price in the supplier's credit agreement. As already seen, the SCA was validated by opinion of the Attorney General and cannot by any stretch be described as a purported contract. It was a binding contract between the GOK and Sound. It cannot be a purported contract in those circumstances. This charge is wholly unsupported by evidence and I hereby dismiss. Next, the count two and the alternative. Again, the payment of 3% of the contractual sum as arrangement, commitment, and management fee was a legal payment and proper obligation of GOK under the clauses of the agreement. It was not established in the evidence that the fifth and sixth accused persons were the beneficial owners. The evidence does not support this count, which must fail and is hereby dismissed. The same fate must befall the alternative count to that count, euros 1.2 million, paid under the SCA, was not the result of any demonstrated corrupt conduct or illegality.